Hello everyone, welcome to Drishti IAS. I'm here again with another episode of Revision with MCQs, and today we are going to cover the subject of polity with the help of various practice questions. So without further ado, let's take a look at the first question. Consider the following statements regarding the veto powers of the President. 1. The absolute veto is usually exercised by the President in the case of private member's bill. Second, the suspensive veto can be applied by the President on all ordinary bills as well as money bills. So here we are looking at two concepts, absolute veto and suspensive veto, as well as private member's bill. So first of all, let's try and understand what exactly does veto mean. Veto usually means, or veto in its literal meaning is I forbid, meaning withholding of assent. Now the President of India has three kinds of veto powers, or the President of India can exercise three kinds of veto powers. What are those? They are absolute veto, suspensive veto, and pocket veto. What happens in the case of absolute veto? As the term suggests, it involves absolutely withholding of assent. So whenever the President withholds their assent to any bill that has been otherwise passed by both houses of the Parliament, it is usually, he or she is usually set to exercise the absolute veto, since there is an absolute withholding of assent. Now, when is the absolute veto power exercised by the President? Usually in two scenarios. The first one is in case of private member's bill. What is a private member's bill? A private member's bill is a bill that is introduced by a member of the Parliament who is not a minister. Hence, this is not a government bill. This is introduced by the private member. And even if this bill is passed by the Parliament and it reaches the President may exercise the absolute veto and withhold this bill from becoming an act. So this is one scenario. Another scenario is also in case of, let's say, government bills. So what happens? So say a government who is in power has introduced a bill which has been passed by both houses of the Parliament. Now what happens is that the government goes out of power and the new government advises the President to withhold their assent on this bill. In that case again, the President exercises veto power, absolute veto. So here absolute veto is usually exercised by the President in the case of private member's bill. This is accurate. Next we have suspensive veto. So what happens in suspensive veto? The President may send the bill back to the House for reconsideration. The President sends the bill back to the Parliament for reconsideration. However, there is a limitation. What is the limitation? That if the Parliament passes the bill again with or without amendments, the President is constitutionally bound to give their assent to the bill. This is known as suspensive veto. Now, your second statement says the suspensive veto can be applied by the President on all ordinary bills as well as money bills. On all ordinary bills, yes, the President can send the bill back for reconsideration. But can the President do so for money bills? No, this is not permitted for money bills because usually the money bills are introduced in the Lok Sabha with the prior permission of the President. So this statement is incorrect and we have option A as the correct answer, which is one only. What is pocket veto power? So if the President does not take any action and keeps the bill with himself without either giving an assent or not giving an assent, either without assenting to the bill or without rejecting it, then it is known as pocket veto. The President has kept the bill in his or her pocket. All right, this is how you can remember. Now this is the detailed explanation. Please pause the video and take a look at it. Question 2, consider the following pairs, power and description. So there are four kinds of powers: pardon, commutation, respite and reprieve. and then of course their descriptions are given. So before we move forward, let's first understand that the pardoning powers of the president are discussed under Article 72. And let's begin with the first power that has been mentioned in the question, which is pardon. When I say pardoning or I pardon you, I am basically forgiving you. I'm absolving you of the crime as well as the punishment. The crime as well as the sentence. So here the description says pardon removes the conviction but not the sentence. This is incorrect. Removes the conviction as well as the sentence. It is the most liberal form of mercy. You're forgiving the crime as well as the punishment. So this pair is clearly incorrectly matched. So all the four can be eliminated from the option. The second one says commutation. Commutation usually means that you substitute a punishment with a lighter form. So let's say life imprisonment is substituted with simple imprisonment, or death sentence is substituted with life imprisonment. So here the description says substituting a punishment with a lighter form. This is accurate description of commutation. So at least one pair is correctly matched. Now the third one says respite, and the description says reducing the period of a sentence without altering its nature. So you're only reducing the duration of a sentence without really altering its nature. So let's say 2 years of rigorous imprisonment has turned into 1 year. You have reduced the duration, but this is not the description of respite but rather of remission. This description has described remission. What happens with respite? In the case of respite, the sentence, the other sentence, the revised sentence is a bit lenient due to some special fact. Like what? Let's say there is a physical disability involved, or the fact of pregnancy for that matter. So when you make or you reduce the sentence, you make the sentence more lenient, then it is known as respite, and you do so because of some special facts. So again, this is not correctly matched. The fourth one is reprieve. Now reprieve usually refers to a temporary stay, so that the convict can actually put in a request with the president, let's say, for putting a stay to his or her execution, or even to they can even put in a request for granting pardon. All right, so this over here, temporary stay of execution to allow time for appeal, that is correctly matched. So here only two pairs have been correctly matched, and therefore option B is your correct answer. Now this is your explanation. Please take a look at it. Question 3, consider the following statements regarding the ordinance-making power of the president. 1. An ordinance, unlike parliamentary law, can abridge fundamental rights if issued during a national emergency. 2. An ordinance can operate retrospectively and may even amend or repeal an existing act of parliament. And 3. An ordinance cannot alter any tax law because taxation powers rest exclusively with the parliament. Now, first of all, let's discuss the ordinance-making power of the president. That is discussed under Article 123. Now, an ordinance is passed when at least one house of the parliament is not in session, and they are passed for the duration of the time of the maximum duration of 6 months and 6 weeks. So whenever the parliament is in session and both houses meet, the ordinance has to be passed to become a law. Otherwise it lapses after or within 6 weeks of the reassembly of the parliament. All right, so this is the maximum duration that an ordinance can have. Now here, since it is basically done in the absence of the sitting of a parliament, therefore it is what? It is like any other law, except that it is not yet passed by the parliament. So it has the same order and same effect as another law of the parliament. That means it also has the same constitutional limitations. If it has the same power, it also has the same constitutional limitations. Now let's take a look at these statements that have been given to us. The first one says, an ordinance, unlike parliamentary law, can abridge fundamental rights if issued during a national emergency. Now, since an ordinance, we have safely established, is like a parliamentary law, right? And since a parliamentary law cannot abridge fundamental rights unless constitutionally approved, therefore, whether during a national emergency or otherwise, an ordinance cannot abridge fundamental rights. It's as simple as that, because it is subject to the same constitutional limitations as an ordinary law. All right. So this is incorrect. The second one says an ordinance can operate retrospectively and may even amend or repeal an existing act of the parliament. Again, this is correct, because like we said, the ordinance has the same order and effect, same power and same effect as an ordinary legislation, and therefore of course it can operate retrospectively and may amend or repeal an existing act of the parliament. So this statement is correct. Now, an ordinance cannot alter any tax law because taxation powers rest exclusively with the parliament. Again, we have been saying the same thing. It is fairly similar to what? It is similar to an ordinary law and other legislation. Patch. It is similar to an ordinary law, another legislation passed by the parliament. So, of course, it can alter tax law. It can also alter or amend another ordinance. All right. So, this again is inaccurate. So, which of the statements given above is or are correct? Statements 2 only, which is your option A. Now, here we have the explanation for you. Kindly take a pause and read the explanation in detail. Question 4, consider the following statements. 1. Unlike the Electoral College for the President, the Electoral College for the Vice President includes both elected and nominated members of Parliament. And second, a candidate for the office of Vice President must not hold any office of profit under the union of a state government, under the union or a state government, but holding an office under a local authority is permitted. So here we are talking about the election to the offices of the President and the Vice President. Now, who conducts the election to the offices of the President as well as the Vice President? Kindly let me know in the comment section. But here, this election is dealt with in Article 54 and 66 respectively. Now, both the elections are conducted in the same manner, meaning an electoral college is involved. It is an indirect election which is done through a single transferable vote and by means of a secret ballot. Now, when we talk about the Electoral College of the President is elected by all the elected members of the Parliament, elected MPs plus elected members of the state legislative assemblies. Nominated members are not included here, and the person who is eligible to be the President of India must also be eligible to be a member of the Lok Sabha. So this is the constitution of the Electoral College for the President. For the Vice President, the Electoral College must consist of the nominated as well as elected members of the Parliament, and members of the state legislative assemblies do not participate over here. So, Here it says, unlike the Electoral College of the President, the Electoral College for the Vice President includes both elected and nominated members of the Parliament. This is absolutely accurate. The second statement says, a candidate for the office of Vice President must not hold any office of profit under the union or a state government, but holding an office under a local authority is permitted. Now, Article 66 will prohibit holding of any office of profit under the Government of India or under the government of any state or any local authority. So, this statement is inaccurate. You cannot hold office of profit in either of the level of government. So this is inaccurate. Now please understand that someone who's a sitting president, or let's say a governor or a minister either in the union or the state, is not deemed to be holding an office of profit and therefore is eligible to be the vice president, or at least to contest for the office of the vice president of India. So here again we have option A, one only, as our answer. This is the explanation in detail. Please pause the video and read it. Question 5. Consider the following statements regarding the appointment of the Prime Minister. 1. A person must first prove his or her majority in the Lok Sabha before being appointed as the Prime Minister. And second, a person who is not a member of either House of Parliament cannot be appointed as Prime Minister. Now here, the President usually has clear mandate as to whom to appoint the Prime Minister, and it is the leader of the majority party in the Lok Sabha. Now here, when we talk about the appointment of the Prime Minister, we are referring to Article 75, which says that the President must appoint a Prime Minister. In case of a clear choice, the Prime Minister is usually the leader of the majority party. However, in cases of a hung assembly, a hung parliament, the President uses his or her discretion and invites the leader of the single largest party, right, or some such coalition to prove their majority on the floor. And usually a grace period is given around, let's say, 1 month or so, or a few days are given so that this leader can, or this party can, prove their majority in the house. And therefore it is not necessary that the person must first prove their majority and then be appointed as the PM. The President may appoint a Prime Minister and then ask him or her to prove their majority. So statement 1 is incorrect. The second statement says a person who is not a member of either House of Parliament cannot be appointed as Prime Minister. Here again, you can appoint a person as the Prime Minister for 6 months, and within these 6 months, they have to get themselves elected or nominated to either of the two houses, to the Lok Sabha or the Rajya Sabha. But they can be elected or they can be appointed the Prime Minister for at least 6 months. So this statement is again inaccurate, and therefore we have option D as the correct answer. So here you have the explanation. Please pause the video, take a look at it. And here you may refer to the 1997 Supreme Court ruling, which held that a person who is not a member of either House of the Parliament may still be appointed as the Prime Minister, provided they become a member of either house within 6 months. However, if they fail to do so, then they would also cease to be the Prime Minister. Next question, consider the following statements. 1. Even after the Lok Sabha is dissolved, the Council of Ministers continues to hold office until a new government is formed. Now, this statement is in fact accurate. So, we know that the President is mandated by Article 74 to function only on the aid and advice of the Prime Minister and his Council of Ministers. So, suppose the government is dissolved and there are no council of ministers, there is no council of ministers. So who is going to aid and advise the president in his or her functioning? So therefore, even if the Lok Sabha is dissolved, the council of ministers does continue to hold office until a new government is formed, and this is basically also mandated in a ruling of the Supreme Court in the UNR Rao case. It is a very famous case. Now, the second statement says the Council of Ministers includes cabinet ministers, ministers of state, deputy ministers, and parliamentary secretaries. So students, this statement is incorrect because the Council of Ministers includes only cabinet ministers, ministers of state, and deputy ministers. And while there are parliamentary secretaries to aid and assist these ministers, they themselves are not a part of the Council of Ministers. Therefore, this is incorrect. The third statement says the salaries and allowances of ministers are determined by the president, since ministers hold office during his pleasure. So here again, the salaries and allowances of ministers are determined by the parliament, not by the president. They are determined by the parliament. So this statement is also inaccurate, and we have option A as the correct answer. Now here, let's take a look at the UNR Rao case. Here, the Supreme Court held that even after the dissolution of the Lok Sabha, the Council of Ministers continues in office. Why? Since Article 74 is mandatory, the President cannot act without the advice of the Council of Ministers, and therefore we have the first statement as incorrect. Please remember this UNR Rao case of 1971. This is of utmost importance. Question 7. Consider the following. 1. Deputy Chairman of the Rajya Sabha. 2. Speaker of the Lok Sabha. And 3. Deputy Speaker of the Lok Sabha. How many of the above are removed by a resolution passed by an effective majority? Now, before we can figure how many of them are removed by an effective majority, let's first understand what effective majority means. So, effective majority means the then members of the House. The then members of the House. Then members meaning the total membership of the House minus the vacancies. Alright, that is the then membership, meaning total membership minus vacancies. When we talk about majority, it means that this number has to be divided by 2 and then 1 is added. So majority, if let's say the total membership of the House is 542 and there are 20 vacancies, so there the majority would be 522 divided by 2 minus 1, which will again be plus 1, which will be 262. This will be the majority in a case like this. So if a resolution is being moved and an effective majority is sought, and this is the situation, so you know that this would be the number. If this number passes that resolution, we will consider it or deem it as have been passed. Now, who all are removed by such a majority? So first of all, the chairman of the Rajya Sabha. Chairman of the Rajya Sabha is removed by such a majority. However, this decision has to be backed by or supported by the Lok Sabha as well. Alright. So in case of the chair of the Rajya Sabha, we know that if an effective majority is passed by the members of the Rajya Sabha, he or she is deemed to have been removed. Now, same goes for the deputy chairman of the Rajya Sabha, because you'd only remove him from the position if they were acting as the chairman. Again, under Article 94, the Speaker of the Lok Sabha is also removed using the same majority, effective majority of the members of the Lok Sabha, and same stands for Deputy Speaker of the Lok Sabha. So, all of the above, all the three or option C is your correct answer. Now here we have the detailed explanation. It refers to the majority of the then members of the House, and of course this type of majority is required in the following cases: Article 67, Article 90, 94. So, removal of the Vice President, Deputy Chairman of the Rajya Sabha, as well as Speaker and Deputy Speaker, both of which are governed under Article 94. I hope this is clear. Question 8. Consider the following statements regarding devices of parliamentary proceedings. 1. During question hour, members may direct questions not only to ministers but also to members, private members. And secondly, 0R is a formal mechanism through which members can raise matters of urgent public importance on the floor of the House. So let's take a look at what exactly is question hour. Now, question hour is basically the first hour of a parliamentary sitting. And here, of course, questions of public importance are raised. Now, these questions may be directed not only to ministers but also to private members, provided that those private members are somehow associated to the bill or resolution or any other business of the House to which the question is directed. So you cannot ask any question to a private member out of the blue, but they have to concern either the bill or any resolution or any other matter that is relating to the business of the House. Now there are different kinds of questions. What are they? So there are starred questions. Now these are questions that are marked with an asterisk. You know what an asterisk is? This is an asterisk, and these questions require what? An oral answer, and supplementary questions may follow. Then we have unstarred questions. These require written answers, and therefore supplementary questions cannot be asked. And then we have another category of questions, which is the short notice questions, and they have to be answered usually within a notice of 10 days. They have a 10 days notice period, and that is why they are called short notice questions, and they have to be answered orally. All right. So anyway, the first statement is correct. The second statement says 0 hour is a formal mechanism. Now, first of all, what is 0 hour? 0 hour, students, is any time that has been allotted to discuss matters of urgent public importance. Now, this 0 hour is assigned after the question hour. So it comes after the question hour and before the regular normal conduct of business of the House. And this is an informal device. This is not a formal mechanism. It is an informal device, and it is an Indian innovation that was established in 1962. This was established in 1962, and then it has become a part of the regular parliamentary procedure. However, the moment you read formal mechanism, you mark it incorrect, because this is an informal device, and of course it discusses matters of urgent public importance. So again, we have A or 1 only as our correct answer. And here, kindly pause the video and read the explanation. Question 9. Consider the following statements regarding parliamentary motions. 1. An adjournment motion can be introduced in either House of Parliament and requires the support of 50 members to be admitted. Now, first of all, we are talking about adjournment motion here, but what exactly is a motion, students? Motion is basically a formal proposal that is given out by a member of the House, either to request that the House take a specific action, or to express an opinion, or to take a decision on a matter of public importance. So a motion is nothing but a formal proposal. A formal proposal by the member of any house. Now, when we talk about adjournment motion, as the term suggests, it is kind of disrupting the regular business of the house, right? And this also happens to be an extraordinary device because it is disrupting the regular normal business of the house. Hence, it is an extraordinary device. Now, why is this adjournment motion introduced? Normally, to draw the attention of the government to an important matter. And this also contains an element of censure, against the government, some sort of a criticism against the government, and therefore it can be admitted only in the Lok Sabha. This motion can be introduced only in the Raj Sabha, meaning it cannot be introduced in the Lok Sabha, I'm sorry, I beg your pardon, meaning it can be introduced only in the Lok Sabha, and the Rajya Sabha cannot introduce this motion. To admit this motion, a support of 50 members has to be needed. It has to be there. So when it says in either house of the parliament, please mark it as incorrect. It can be introduced only in the Lok Sabha. Second, a confidence motion is generally moved by the opposition parties to require the government to prove its majority in the Lok Sabha. Now, as the name suggests, absolutely confidence motion does require the government to prove its majority in the Lok Sabha. This is indeed the function of the confidence motion. But when is a confidence motion introduced? So usually, like we discussed a couple of questions earlier, in the case of a hung assembly, hung parliament, when the majority of the party is either slim or uncertain, then the president may call the leader to prove the majority on the floor of the house. Sometimes the government itself proposes that let's introduce the confidence motion so that we can prove our majority, or we can prove that we have the majority of the Lok Sabha. So, no, it is not generally moved by the opposition parties. It can be moved by the president or even by the government itself. So, this statement is also inaccurate, and we have option D as the correct answer. So, here, please take a moment, pause the video. Final question. Consider the following statements regarding financial bills in India. 1. A financial bill. 2. Like a money bill, can be introduced only in the Lok Sabha and not in the Rajya Sabha. The second statement says a financial bill 1 cannot be passed by either house of the parliament unless the president recommends its consideration. So we have the first statement which discusses financial bill 2. So first of all, financial bill 2 is governed under Article 117 clause 3. And what does the financial bill 2 contain? It contains all matters related to the expenditure from the consolidated fund of India minus matters related to, except for matters that are contained in Article 110, the money bill. So minus these, barring these, matters that are related to the consolidated fund of India are contained in the financial bill 2 under Article 117 clause 3. Now, for all purposes, it is considered as an ordinary legislation. So if it is an ordinary legislation, it can be introduced in either house of the parliament. So with that piece of information, our first statement becomes incorrect. All right. However, it has a special feature, which means at the stage of consideration, it cannot be passed by any house of the parliament without the president's prior recommendation. So before the bill is put to vote, the president recommends, and therefore only then it is put to vote. So here, when we say at the stage of consideration, we mean that before the bill is put to vote, the president's recommendation is needed. That is the special feature of this category of bills. The second statement says a financial bill 1 cannot be passed by either House of Parliament unless the President recommends its consideration. So here you can see that this actually is the description of financial bill 2. So financial bill 1 is actually governed under Article 117 clause 1. The statement we know is incorrect, but here President's prior recommendation is actually needed, but only at the stage of introduction. Before introducing the bill, the President's recommendation is mandatory, but at the stage of consideration, like it's mentioned here in the statement, it is not. It is actually the description of the first one, and here they have actually interchanged the descriptions because this can be introduced only in the Lok Sabha. And what does it contain? It contains all matters that are contained under Article 110 as well as certain other legislative matters. So here this is similar to money bill in the sense that President's prior recommendation is needed before this bill's introduction in the Lok Sabha. The bill can only be introduced in the Lok Sabha, and of course at the stage of consideration it is not required that it take the President's recommendation, and otherwise it is considered and passed as an ordinary legislation. So this is the difference that you all ought to remember. This is the explanation. And of course, with this, we have both of these as incorrect because the description and the explanation has been interchanged, and we have option D, neither 1 nor 2 as the correct answer. This is the explanation. Please pause the video, take a look at it. Now here, I have a practice question for you as well. Kindly look at your screens, read this question properly, take some time to attempt it. And once you are through, please do send me your answers in the comment section. If you found today's video fruitful, please like, share and subscribe, and thanks for watching.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.